the totality of the circumstances, we can watch the video, but he says the exact same things and created a website. It says the same things, so you can watch him saying these things, and then what the sex sites say.
And Your Honor, just to be clear, Judge Eggleston.
Only one at a time.
Judge.
I know it's hard.
Yes. Yes.
It's harder with twins, I don't. I have twin nephews and they finish each other's sentences all the time. I understand where you're coming from. Especially in a situation like this, but only one at a time.
Judge Eggleston recused himself during the length of protective orders. He recused himself because of...
Your Honor, I'm going to reject anything about the recusal.
Motion in here, and I'm going to accept that on face value, recuse myself on previous hearings, and of course that was granted by the Supreme Court of Virginia. That's why I'm here.
And I only brought it up again, Your Honor, because that's one of the...
Objection, Your Honor.
That's one of the things that Mr. Gutenberger says in the video, is that he made Judge Eggleston recuse
Your Honor, I'm going to
himself.
object to this video. I mean, it's hearsay. Where's the video?
Okay, I'd be happy to play it. But the point is that the exact same language from this video and this website that Mr. Gutenberger made, as the hundreds of others posts that he's done about us, states, always in these sex and dating sites that he's posted us on, always states something like, Brittany Deane, Briana Deane.
Your Honor, objection. It's hearsay. Objection.
I will show it. May I approach them?
Well, does Mr. Straw, has he seen these things?
No, no, sir.
Okay.
I mean, it's a whole issue at this stage, these social media posts. Y'all have not had any direct contact with him. Is there any phone calls from him?
Your Honor, as has been presented to the court previously, Scott Gutenberger admitted in court that it was him who was posting all of these things about raping the Deane twins and...
Your Honor, I'm going to object to that characterization. That's not the testimony that was given.
I'd like to go ahead and then approach with this, and maybe Mr. Is it Straw?
Yes, ma'am.
Yeah.
Yeah, Mr. Straw, see that, Mr. Bailiff?
As I was saying, as Scott Gutenberger and his counsel have conceded and admitted in court, Scott Gutenberger has a history of posting things about Briana Deane and rape, the Deane twins and rape, and he has stated, I'm going to ruin them. He has told previous judges, my goal is to ruin the
Objection, Your Honor.
and to...
Yeah, we do need to stick. What I want to stick to, well, is things that have happened in that, and obviously things happen.
Yes, Your Honor, I understand.
Only one of which resulted in a conviction also.
So in the evidence that we have presented that is sitting there in Mr. Straw's hands, the latest date was December and January of this year, where new things have gone up, but they're identical. There are names and images are all over these sex sites, these pornographic sites, and they call us by name, they give our location, and they say the identical things that Scott Gutenberger stated in court he was going to try and make happen.
The sex sites, it states Brittany and Briana Deane lie in Amherst Court, along with Steve and Nate, who was our one witness in Amherst Court, along with our father, who was also protected in the protective orders. It will say they lied in Amherst Court, similar things like that, and then when you click on it, it takes you to a site, or sites, multiple sites, that state things like, find a woman in Virginia, and excuse the language, Your Honor, but these women don't want to date, they want a quick fuck, they're looking for some fun, pick a, and it takes you to pornography, nude women, Brittany and Briana Deane, our names on it. He's released our contact information before. He even went as far as to create a website where he posted text proudly between him, and we don't know everyone he's working with, between himself and people who were our neighbors, and giving him a play-by-play of our actions. And so he very well continues to stalk us, knows our whereabouts, and the obsession is absolutely terrifying.
And Your Honor, the last thing I wanted to make clear, we mentioned before about the video of Scott Gutenberger, and we've got the link and image there in Mr. Straw's hand. But our point, Your Honor, was to say that Judge Eggleston recused himself after seeing this video. It would not be fair of the court to say, we know it's Scott Gutenberger when it's to protect the judge, but we're going to say the victims have to prove that it's him. Hope that makes sense. Sounds like the court had already decided that that was him.
So in previous open court testimony, Mr. Gutenberger admitted it was himself.
That is correct, and then also Judge Eggleston, when we were not in court, we found out that Judge Eggleston had, because he knew all of these posts that Scott Gutenberger was making online about Judge Eggleston were accurate and made by Scott Gutenberger, that he had to recuse himself. That's what we were told. He felt threatened, and so it wouldn't be fair.
Now you're getting beyond. I mean, Judge Eggleston is not here seeking infection. Okay.
Oh yes, Your Honor. I understand that totally. My only point in saying that, Your Honor.
Well, I don't know which point. Your point is to prejudice.
No, Your Honor.
The defendant, I mean the respondent, and of course, what I'm most concerned about is what has he done directly with respect to Briana and Brittany Deane.
And so we had presented evidence that shows in the last couple of months things he's done. But I want to go back to, Your Honor, the main point is that statute 18.2-60.4 says, upon conviction, the court shall, in addition to the sentence.
That's why we're conducting this again.
Yes.
Or allowing him to stay.
I don't know that we are required to even go into evidence, although we're happy to do that and have
done so. Well, the only
so.
problem is the judge did not handle that case, did not issue a correct order, apparently, for some reason, not a lot. But anyway, maybe one way to approach it would have been to go back and ask that be reopened in circuit court before that happened, but that wasn't done.
Your Honor, we've tried and have documented that in writing in our file.
Okay.
That we have attempted.
But the key thing is we're still within the 2-year limit for the original 2016 protect order, and that's why we're simply, it matters not whether a protect order is issued by a judge of circuit court or a judge of general district court or judge of our court. All our court orders can remain in effect until they expire. So this one's still on. That's why we're here. Now, Mr. Straw, you've seen Deane twins linked to that is.
You have a host of objections, Your Honor. I mean, hearsay, foundation, well, the admissibility for lack of a foundation. I do see Scott Gutenberger's face on the very last page.
Okay.
Doesn't appear to have anything to do with the Deane twins. It looks like it's, well, I'll let the court read for itself.
All right, except for the extra little note on there, but.
And in the alternative, Your Honor, it's not contact, but I digress. I'm not saying that it's authenticated to begin with. Certainly,
the opposing counsel stated
Your Honor, I
that
wasn't finished making my argument.
Yeah, so let him finish there.
Again, it's the authentication of the documents. I don't know where they came from. It looks like there's a website address at the top. Certainly looks like it was printed offline. There's a host of images that are attached that I can't see what they are. But namely,
they're
there's
in the
no
back, Your Honor. I printed them bigger in the back.
There's no authentication to the documents. I don't know where they came from. It certainly does have their name, and it looks like it's linked to some type of porn site or search engine or something of that sort. But I guess my question would be, if everything that the petitioners are testifying to are true, does that in and of itself present the likelihood of bodily harm? I mean, that's what the protective order is for, is bodily harm. I mean, if you look at 19.2-152.10, it has 3 subsections, and they all discuss exactly what triggers either a violation or what triggers the court beyond a preponderance of the evidence to issue a preliminary or a final protective order to begin with.
Right.
Your Honor, may I?
Yeah, I'm finished. That's my argument.
Well, yeah.
Just for the admissibility of those documents.
It's necessary to prevent acts of violence, force, or threat criminal offenses that may result in injury to personal property or communication or other contact of any kind by the respondent.
Your Honor, when Judge Eggleston issued the permanent protective orders on February 10th, 2016, he quoted a case, and it's become, precedent in Virginia, that stalking is now, when an individual tells someone, do not contact me, and that person, after being told concretely, do not contact me again, contacts the person even one time, it is now considered stalking in the state of Virginia. And stalking is something that the opposing counsel statute covers as an act of violence. Your Honor, I can't think of a more violent act than inviting people to teach the Dean twins a lesson, talking about rape me dash Brittany Deane and Briana Deane with the Nirvana song Rape Me blasting in the background. I can't think of, along with our contact information, I can't think of anything that is more threatening as far as a violent act. Linking our names to sex websites, saying that we're in Virginia and that these women want a quick F-U-C-K is beyond terrifying. We have had, what he does is he goes online and invites people to harm us, both mentally
Your Honor, I'm
and
object
physically.
to the characterization. Is this testimony or argument?
She's still speaking.
And
But I objected.
Your Honor, may I just finish my thought?
Sure.
Of course we are going to run into being able to 100% prove that it's someone. I could go into that, but we have had our windshield beaten in.
Objection.
Well, these things are,
I know.
I don't know where they happen. Did they happen here?
It's reported to the police.
Here? In Amherst?
No. I will.
So,
I would.
What your argument is, basically, or what your testimony is that there were notations on some websites calling on people to, essentially teach you a lesson or whatever the exact words were, and as a result of that, acts of violence did occur. Your allegation is that acts of violence occurred because of what was written on the website. I hope they get what's coming to them, things like that. When was that? That was
Multiple times.
It's just so many times.
Did any of that give rise to the conviction?
No, sir.
That's actually incorrect. He was convicted on some social media issues.
Your Honor, that's incorrect.
He was charged.
Your Honor, he was convicted of waving and saying, "I'll see you guys later," outside here on these steps.
Okay.
And I guess I'll use that as an example. That's still one contact that's happened while these current protective orders have been in place. He was convicted of contacting us in violation of the protective orders on July 26, 2017.
When he says, "I'll see you later," he makes sure he sees us later, whether it's online or in person. And the protective orders specifically prohibit him from posting on social media, online about us for very specific reasons. Only a drop in the bucket of what we just went over. Your Honor, we ask that we are dealing with an obsession here. We have come time and time again to the court, for some help and protection. Please renew the protective orders and impose the law that should have been imposed anyway under 18.2, 60.4.
He's so desperate, it seems, to not have you impose this because in a few days when these current ones expire, the hell is going to start up even worse again.
Well, that's always the risk you run when a protective order expires. I mean, ultimately, they may not be renewed, and at a certain point, they actually do expire. Somebody might serve jail time for violation of a protective order, and I assume, was there any jail time imposed?
It was 2 weeks, Your Honor.
Yeah.
Oh, actually, that's incorrect.
I would say, is there nothing anybody says here that's correct?
Your Honor, he got a 30-day sentence, but he
Where's the
served.
sentencing order?
It was I think a 40-day sentence, wasn't it?
Okay.
It was misdemeanor time, so it was half of the
So you
sentence.
got half that.
Well, it was a year, but then it was suspended.
Your Honor, it was jail time in answer to your original question.
There was jail time, sir, whether it was 10 seconds or 10 days or much more. But the bottom line is, my point is, at some point, every jail sentence does come to an end. So, I mean, there's nothing any court can do in some ways to, I guess, you know, you're not, well, there are things that can be done that involve life sentences and other things, not for violation of protective order. But if there are other associated issues that happen, crimes of violence, things like that, or homicides, I mean, obviously there's things that can trigger much more serious sentences. But most people eventually come out of jail. So my point is that no court can guarantee a sublime universe just because an order is entered, but certainly the court can enter an order. Now, the point is, there was a conviction in circuit court sometime while this 2-year protective order was in place.
Yes, sir.
And there. All right, you all have had a lot of testimony. I don't know if Mr. Gutenberg even wants to testify or not.
I would just like to ask a couple of questions.
Absolutely. This will be cross-examination then, based upon the testimony that has been heard from both Brittany and Briana.
Do either one of you still live in Virginia?
We are not going to answer that in front of the
That
stalker.
question's already been answered.
I didn't. Were they under oath when I didn't hear that?
We are not. Mr. Straw, I would advise you not to assist the stalker in help in stalking us.
Are you saying that somebody in this court's not entitled to representation?
No, Your Honor.
There has been a concern brought up before that he is being helped by the magistrate and his own counsel to find where we live and continue the stalking. We have had to move. The stalking was so bad that we have had to move. We do not want to say where. We assume he may not already know. In case he doesn't,
Right.
so
the question was asked.
please don't ask us
I
that.
recall you were under oath this morning when I asked you if you still lived in Virginia, and that was, of course, and if you weren't, you're under oath now when you're answering and say that you do not live in the Commonwealth of Virginia.
Well, what may I tell you without saying in front of?
I don't need to know it.
Okay.
All I need to know is whether you, but I don't really need to know that.
Yeah, I don't care where they live. They don't live in Virginia. We've established that. Other than
Did you just say that we don't live in Virginia? Was that your statement, though?
It's not making a statement. He's asking questions, okay?
Okay.
He's not under oath. He's not a witness. But you all said you don't live in Virginia.
No, Your Honor,
we
that's
did not
actually
say
not
that.
what we said.
You don't?
We said we did not feel
We said-
comfortable answering
Okay.
in front of the stalker.
Well, for reasons of establishing jurisdiction, I think the question was asked whether you lived in Amherst County, and most certainly the answer to that is percent. Right? Or do you?
We would be happy, Your
Can
Honor,
we
But
tell
I think
you
I
in
ruled on it,
chambers?
notwithstanding whether you live in Amherst County or not. You know, people can get in, well, you know, for instance, in Harrisburg, JMU students come there from Long Island and San Francisco, and problems arise while they're in Harrisburg as students. Or people come to Massanutten for a weekend there, and they get in a big brouhaha, and protective orders issued, and then they come back to court later on to see what's happened. But bottom line is, wherever they live really does not become the operative issue. The question becomes, what is the jurisdiction where the incident occurred? And in this case, the violation of the protective order.
then you would be proper where the violation would have occurred. Yes, sir. And that's what I was getting at. Is if at any time in the last.
Well, there was waving outside on the front porch.
Sure. Yes, sir. But I'm not even. I'm not.
We'll see you later.
We're past that. He was
We are
convicted of
shortly.
that.
But, you know, there are things here that we, and there always are in protective orders, words spoken, gestures, even Facebook postings and stuff that goes on social media that can be taken various ways. You know, maybe it's harmless to wave at somebody and say, well, I'll see you later, but when you're under a protective order, I don't know that anything's harmless, right?
I'm not arguing that he was convicted of that. He was convicted of that.
And it was because of that.
Yes, sir. That was the sole.
Face-to-face waving.
That was the sole reason for his conviction. There were other charges that included posts on social media.
Right.
Those were dismissed because the judge read the language of the protective order upstairs and basically said, I don't find that Judge Eggleston meant to write, you can't post anything at all, restricting free speech 100%. He found that what he meant to write was that you can't post anything that's directed to be a contact toward the petitioners.
Sure. Well,
so those were dismissed. But Your Honor, I'm not arguing the violation. That ship has sailed. And Judge Garrett upstairs did not.
It didn't say, oh, it was a protective order being extended.
But it was not extended upstairs when it says upon conviction.
And maybe, you know, again, conjecture, maybe he said, well, protective order is still in place if I touch it. But
Well, he had the option to extend it for a period of up to 2 years, so
more years.
he could have extended it for 1 minute had he chosen to.
That's right. That's right. It didn't have to be 2 years.
But in any event, the gravamen of my question for the
Yeah, back to you.
petitioners while they were under oath was for the court to determine whether or not venue's proper,
Right.
whether or not jurisdiction, personal jurisdiction is proper. The order is still in place, so it can be extended. But if nothing has happened that would give rise beyond a preponderance of the evidence that bodily injury, imminent death, then I just don't see it. That's what the question was going towards. So my only other question for these petitioners, and I'll be quiet and sit down, is other than when you have been in court in this building or outside the grounds of this court, have you seen Scott Gutenberger in the last 2 years?
We have wondered twice if we have, as far as physically seeing him, times that were not when he was in court.
Well, the answer is either yes or no. Have you seen him in the last 2 years?
No, that's not the answer. The
Other
answer
than-
is what is the truth, and I'm telling you that there have been 2 concrete times, which is why I said I believe he knows where we live. We have talked with the police. That was not determined 100%.
Where did you see him?
I don't want to, it goes back to the same issue that we saw him where we live.
Have you spoken to him on the telephone in the last 2 years?
I believe I have received many phone calls from him. I cannot prove beyond the totality of the circumstances that I have hundreds of calls from him. We get calls all the time when someone hangs up.
And we have been contacted online from on a Twitter account that Scott Gutenberger has admitted in court as to being an account that he created and shares with a few other people who.
Is that since we were last in court?
Excuse me. Yes.
Is that did you go to the magistrate in Amherst County about that?
Oh, everything's been turned over to Captain Breiser and Andrew Childress.
Who we understand Andrew Childress is.
Okay. I don't have any other questions, Your Honor.
All right. At this stage, then, you all have presented the verbal testimony under oath, and it's going to be your turn if you wish to call.
I have one question for my client, Your Honor.
Okay.
Do you still live in Virginia, sir, or have you ever lived in Virginia?
No,
Okay, that's all the
Ever
question.
lived in Virginia?
no, never. I'm a resident and have been.
Sir, just please just
Colorado.
answer. Please just answer the questions I'm asking you, okay?
Sure.
Have you ever lived in Virginia?
No,
Do you live in Virginia now?
no.
That's all the questions I have. Well, no, I do have one more question. When this order was entered in February of 2016, where did you live then?
Colorado.
That's all the questions I have.
Your Honor, that's not his testimony to the judge the last time we were in court on July 26th. He stated something on recording that is not the case, but who knows what the truth is. He's nomadic on purpose.
He stated that he had moved to Florida and then New York City for a new job the last time he was in court. So now he's saying
Your Honor, I'll
Colorado.
object if there's no foundation for that statement.
It was in court.
You're certainly, well, I'm not going to tell the judge how to do it, but you can ask my client a question if you'd like to ask him a question.
Yeah, he is subject to cross-examination.
With us being the victims of a stalker, I didn't know, but if you're saying
That would be contact, but
Well, we're in court, and I think this is the most protected place. Well, there's one more protected place. You've been there, but as far yes, you're entitled to cross-examination.
Mr. Gutenberger, did you state on July 26th, 2017, last time that we were in court, that you had moved from Colorado?
No, I did not.
Did you state?
And then the question is, where do you, Scott Gutenberger, live now?
Colorado.
What is your address?
I'm not going to give that to my stalkers.
All right, this is not Judge Judy. So the question's asked, it's going to be up to me to determine whether you have to give your address. You're going to have to be served, if there's an extension of the protective order, you have to be served with it. But you don't necessarily, I guess they do need that though for criminal history purposes.
I live in Denver.
The question was his address, Your Honor.
I think the courts have my address. They were able to contact me to bring me here.
If there is an extension of the protective order, then you would have to give that to the sheriff who serves that on you, so that there's some kind of follow-up here and go properly in your criminal history instead of somebody else's. Only an issue of identity would be the only reason for that. I don't necessarily need to have it today. And I think you're telling me you're in Denver.
Correct.
May I ask my next question, Your Honor?
All right.
Mr. Gutenberger, did you state last time we were in court on July 26, 2017, that you had moved from Colorado to Florida?
No, my father lives in
Yes or no?
Florida.
Just yes or no?
No.
You did not. Did you state last time we were in court on July 26, 2017, that you were about to move to New York for a new job?
No.
Your Honor, I guess I would let
Scott Gutenberger, did you state in court previously that you own the Twitter page, the Fake Dean Twins?
Your Honor, that exceeds the scope of my direct.
It does exceed the scope of direct examination. And with respect to that, I won't go out.
And then the last question then, Scott Gutenberger, have you posted anything about or
Objection, Your
pertaining
Honor.
to Brittany and
Scope
in the,
of direct examination.
did you say, I need to stop, Your Honor?
Yes. That's what I said.
So, Your Honor, I would just like to say that constantly stating, what opposing counsel, Mr. Gutenberger, does every time we're in court is state as a reason why you shouldn't grant us the protection that we're asking for is because he's not in Virginia or he's moved from that address, and whatever the story changes, no matter what they think is going to help their case. He's lied in court. We can produce that recording, I'm sure, about his whereabouts. We don't, the opposing counsel doesn't, I'm sorry?
Is there a court transcript?
That would be our question to you.
What
We
is
don't
the
know.
report?
I believe that
I didn't have a
witnesses
transcript.
were given permission to record.
Oh, wait, he said, counsel said he has the transcript?
I said I do not have a transcript. I didn't order a report that day, Your Honor.
Opposing counsel, at least multiple times has asked to record, and so I believe opposing counsel does have that recording, which
Well,
will.
wait a minute, he's saying he doesn't as an officer of the court. He's advised, and none of those stages were you court appointed, right?
I've been retained, but I've never ordered a court reporter, Your Honor.
Right. And if you're a retained counsel, then you would have to specifically, the court's not going to order it under the same statute that would allow for a court appointed attorney at state expense.
Does that apply to us as well, Your Honor, the victims? I'm asking a genuine question. I'm
Yes,
not
if
being.
you needed to get well, number one, there would have to be a court reporter there to begin with, but there's nothing of record to go back and prepare a transcript.
But if we have a recording, would that be helpful to you?
If there was a recording made,
But I
and
guess,
with the judge's permission in a misdemeanor case,
yes.
then it could be given some weight. But I mean, what's your point? Is your
My point, Your Honor,
that he's lied specifically about
no.
his whereabouts?
Your Honor, my point is that opposing counsel made the specific point to say, Your Honor, he doesn't live in Virginia. He's not harming these girls. We don't know where he lives. Opposing counsel, I hope, doesn't know where he lives, and that's genuine. But he has lied in court last time about where he lives. He may very well live right down the street from us. We don't know. Opposing counsel obviously doesn't know and is not owning up to the fact of what Scott Gutenberger said multiple times last time in court about how he was not in Colorado, about how he had moved to Florida, and was in the process of moving to New York for this great new job as a marketing director. And he testified to that multiple times.
And Your Honor, I would just like to go back. I think we're getting a little off course because from what I can tell, the only thing that we really have to show under statute 18.2-60.4 was that he was convicted. And he was. He was convicted on July 26, 2017. Your Honor, I don't know why we were told that the judge was issuing that, and then suddenly found out now that, oh, there was something. But Your Honor, I would hope that the previous court's error would not be something we have to suffer as the victims. I hope it can be corrected today, and thank you.
Okay. I'll take that as closing argument, essentially, of the petitioners.
Only, Your Honor, that we ask that the full 2 years, that would be the time that we request.
All right.
with the same provisions as the current ones that are about to expire. Thank you.
Well, anyway, we'll go into that if we have to. Anyway, Mr. Shaw.
Your Honor, I'll just argue that if petitioner's basis for this hearing and an extension for the protective order is the fact that he was convicted, they're in the wrong court. And that's within the jurisdiction of Judge Garrett upstairs. If it was a mistake or if it was oversight, I don't know, but I think that a sentencing modification would have to be done upstairs because the statute says that the court shall upon conviction. Today we are not upon conviction. Judge Garrett was upon conviction in July of last year. I don't think that means he loses his right to do it. I'm certainly not giving the petitioner's legal advice, but we're just not in the right court. Where that leaves this court today, I would argue, is has there been some type of an act since the first protective order was entered that gives this court pause and for this court to find beyond a preponderance that there is still a health or safety issue that exists today that existed in the same light when the first protective order was entered. And I would argue that there has not been. The only evidence the petitioners have put forth before the court, they actually haven't even put forth the fact that he was convicted. We stipulated to that. They've given the court documents that had not been I'm sorry, Your Honor. They've given the court documents that haven't been authenticated in any way, and therefore they're hearsay. There's been no type of a business record exception. There's been no admission under oath by Mr. Gutenberger that he has anything to do with this. It has their names. We don't know where they came from. The only thing that the petitioners have put before the court today as evidence is only what we've stipulated to, and that is that he was convicted of a direct contact, which its nature was, hey guys, I'll see you later. Anybody's certainly free to interpret that however they want. I'm not telling the court how to interpret that because the court didn't hear that evidence. The court upstairs did. And the court upstairs convicted him of that, and the court upstairs is who had statutory authority at that time to extend the order for a period of not 2 years, but up to 2 years. It very well could have been that the circuit court wasn't going to extend it beyond a day and therefore didn't want to fool with it. But certainly that wasn't done. So where this court again is,
why it wasn't done.
There's no indication. I can't represent to the court why because I don't know. But where this court is today is
Judge Garrett down to ask him
at least not here. But there's certainly nothing before the court today that I've heard that gives rise to a preponderant standard of health and safety. Whether there is or not is irrelevant. There's been no evidence to that effect today. The court has the discretion to extend it for the additional 2 years. But even the statute itself doesn't even go into what the burden is. I assume that the statutory construction of the General Assembly would be the hearing the court can extend, but I'm assuming that it would be the same factors as what gave rise to put the first one in place to begin with, which is health and safety. That's subsection B of 19.152.10. What the petitioners are quoting in terms of the 18.260.4, that's the conviction statute and what the circuit court could have and should have done at that time, which is not even relevant today to today's proceeding. It's how does this court feel the threat continues to exist? And Your Honor, there's been no evidence of a continued threat. There's been no authenticated evidence of a continued threat. There's been no testimony on my client's part of a continued threat. And we don't know where the petitioners live, but they certainly have testified that they don't live in Virginia.
That's false.
I think
The court has stipulated, or the court's found.
That at least in Amherst County, Virginia.
At least in Amherst County.
And
Which
I'm
is,
not even sure they testified that day.
but that's for venue.
They were very concerned about their safety and him having any inkling as to where they live. One way that people can be contacted without, wherever they live, or can be indirectly contacted, is by social media. It doesn't really matter if they live in Amherst or they live in Virginia or New York.
There's been no evidence of that here today, Your Honor. There's been no contact via social media presented as evidence here today.
Right, but that is a concern that Judge Eggleston obviously had. And anyway, you're entitled to the last word. One of you, however you want to start with that.
We've been through hell. It's been a horrible couple of years, and the hell has continued. We go to bed scared every night that we're going to get raped in our beds. We are always scared of seeing him in our rearview mirror. We are always scared that he is going to make good on the threat that he gave, that he was convicted of, saying, I'll see you guys later. My twin sister and I have been through enough. The current ones expire in a few days. We've asked the court to renew them so that we are not subjected to even more hell that we know will begin. And we ask the court to please renew the protective orders. It is also not our fault that the previous court didn't follow the statute, but we came here today as we were told we needed to get a renewal.
All right, well, whatever happened in circuit court again is relevant only to the extent that I guess it did involve direct contact of both of the petitioners by the respondent, as I understand the testimony, ALC later, whatever it was. And one piece of the protective order that was entered in February of 2016 that seems to be abundantly clear. The court orders that the respondent shall have no contact of any kind with the petitioner. It's a broad language. But it's designed, and certainly Mr. Straw, I'm sure your client understand, if you run into them at the local Walmart, that's not the place to extend friendly greetings, because I think it's very, very clear that these respondents want, or these petitioners want nothing to do with you. Nothing. No contact, no friendly wave, oh hi. No any other form of greeting with a wave or a finger or whatever it happens to be, and I don't know. I wasn't there. I didn't even hear the case in circuit court, but obviously you admitted, or I think at least were convicted of having contact directly with them right here in front of the court. And you know, a piece of that really concerns me, because when protective orders are issued, you at least want somebody to get away from the courthouse before they violate it, if there's going to have to be a violation because of some weird reason. And this happened right on the steps of the courthouse. So I don't really know that I need to dig too deeply into a whole lot of other things, posting on websites, things that you may not have even posted, or maybe some third party had something to do with posting. These folks don't want to see you in their rearview mirror. If you're driving on Route 66, interstate, or the other one, out in the west someplace, until Las Vegas goes. But anyway, if you happen to see them, then it's not up to them to avoid you. You know, that's not the burden. And these protective orders are not issued lightly. But violations of them can't be ignored either. Now, the violation part of course, was already dealt with in terms of whether there was a conviction for violation of a protective order, and of course there was. And jail time was served, so there was a penalty. And I don't know if, you know, if it's something that you don't understand or are not going to be able to get behind you, then I certainly hope that whatever you need to do to get it behind you, get it behind you. Because I think the other thing that's very clear is that Brittany and Briana Deane are going to take this very seriously. And it's easy to get a warrant from a magistrate. I'm not saying it's a perfect system. I'm not saying it's a corrupt system. I am saying that it's easy to get a warrant from a magistrate. And the magistrates, because this has mandatory jail time, no matter, it doesn't have to be a year or anything, but it does have a mandatory sentence that's involved. They do take charges of violations of protective orders very seriously, and they hold people in jail until they get to come to court. And that's the magistrate's discretion, and usually, at least at that stage, you know, it's going to be upheld by a judge until there's a hearing date. Now, you've been through that process once, maybe more than that, because there were other allegations, I think, of other court cases, other court dates, perhaps, that all went along with that stuff. But I'm real concerned when I hear of any kind of contact, especially direct contact, because I've always made the point with any protective order when I issue them, it's like, you understand that you shall have no contact of any kind with the petitioner. That means one-on-one, here we are, they're across the room, and you say something to them. That's direct contact. Simple as that. I mean, you do it on the front steps of the courthouse. That's direct contact. It doesn't have to be assaultive behavior. And so that's what, now, and obviously that is viewed in the context of, is there something there that's going to cause a reasonable apprehension of bodily harm, those kinds of things. And I think that becomes very subjective, because one person's apprehension is going to be different than another person. And what Brittany and Briana Deane are looking at is a larger context there perhaps than you are. And it would be up to the court to determine in any case in the future whether there was going to be truly, beyond a reasonable doubt, a criminal act that occurred. Magistrates have no probable cause. They can issue a warrant pretty easily. And somebody goes in and swears out a warrant, and you know, sometimes warrants are sworn out that turn out not to be true. And you know, other repercussions exist for folks that swear out warrants that aren't true. But the bottom line is, that's not where we are. We don't want to get back to that point. I don't want them to have to get back to that point. I really don't want you to have to get back to that point. I want this thing to move on somehow, so that everybody can get on with life. If you go to Colorado or Kalamazoo, I don't care. You know, just on from a legal standpoint, what I do care about is that you have no contact with Briana and Brittany Deane. I don't know what the problem is there. If there is an obsession, as they feel, that's not really the standard I have to hold. You know, I'm not accusing you of being an obsessor or a stalker. I'm just determining whether to extend the protective order.
Did I mention the fact that the circuit court order, the sentencing order, did provide for no contact?
Good. Well, that's a good point.
I mean, I don't know if that renders a preliminary protective order or protective order.
What I think it does do, and what I'm going to do, is try to keep this in some sense of perspective. And I don't know if it's fair to do that or not. I'm going to extend the protective order for 1 year. I don't think it needs to be extended 2 more years at this stage. There are other orders in place as far as the circuit court, and I do look at it from the standpoint that what happened has been in violation of protective orders, been down that way. So I can't ignore it. But by the same token, I'm not going to drag this thing out 2 years. I'm just leave it 1 year. 1 year from today's date, essentially. And the way I'm going to word it, and I'm going to go back here and try to artfully work this out, because I know Judge Eggleston tried to, and his language was found to be
overbroad,
clear or something. But I'm going to check on there that we've had a full hearing, no question about that. The respondent shall have no contact of any kind, shall also not commit any acts of violence, force, or threat, or criminal offenses that may result in injury to the person or property. You know, it's always subject to interpretation as to what that is, and then that you have no contact of any kind, well, with William or Deborah, I guess, being the additional parties that were sought to be added to the original protective order and are still on there as far as this one. So they, again, no contact of any kind, no exceptions. My point when I say no exceptions is no direct contact, no indirect contact, no third party contact. You will not make any kind of contact. Now, when we get to the social media, I don't know, I wish there was a way under free speech to have absolutely no contact. I can't, you know, we get far afield when I say no third party contact through social media or something like that. Because one of your friends may pick up something and say, you know, that protective order sucks, this is ridiculous, you know, these people have made false accusations or whatever that you didn't even know about. But I will definitely say in there that, I mean, how can it be more clear? Judge Eggleston wrote it in a way that makes sense to me. Respondent may not post any material on social media regarding petition. Respondent. You know, I don't know if you had this website or what it was, but you know, you can't put stuff on there. I don't know how you control everybody on the planet reading something. You know, social media is such a disaster, you guys. You know, there are times when it's wonderful, instant communications is perfect, you know, but it's not. It's gross. So that's how we get to these things.
Just context, Your Honor, where that left him last time was when he got online after the court hearing. He said something to the effect of, or he posted something to the effect of, just got out of court today, justice was done, blah, blah, blah. And although it wasn't a message that he sent
Right.
to the petitioners.
I mean, make it clear
The
that
petitioners
you
were
guys
able to
sent them
read it.
something.
So that's not contact, is what our argument was, as long as it's not, I mean,
Yeah,
that really
Your Honor,
gets into.
that's not what it stemmed from. It stemmed from rape stuff about the Dean twins.
Sure. Well,
So let's not please
why would
minimize
you
it,
mention
please.
them-
Why
Why would you
mention
mention
it?
this proceeding on social media? Is there any reason it has to be mentioned on social media?
We're getting into First Amendment issues when we make it that broad, it's.
Right.
Yeah, well, there was a reason,
No,
actually. There was a reason. And
Scott,
this-
don't say anything, please. Sit. We're getting into First Amendment grounds when we do that. We're getting into overbreadth when we do that. I think Mr.
That was ruled
Gutenberger.
on already, Your Honor.
Well, it's ruled, there's no conviction for it.
That's right.
No,
Miss-
But it was ruled on that he already asked this in circuit court, if it was overbroad, and the decision was that no, it is not.
That's
Your
why
Honor,
it was
I worked on the famous Craigslist rapist case where an ex-boyfriend went on, posted a photo of his ex-girlfriend inviting men to rape her, and gave her
Is this that
contact.
case?
I'm sorry,
Is this that case?
Your Honor. He knows that I worked on that case. He knows it terrifies me.
You didn't work. I mean, why are we doing that?
My point is that it is not that he went online and said justice must be served about my case. It is so much deeper and more violent than that. So I'm just responding to opposing counsel. He is making it something that it is not. We don't want him to post about us. We don't want to have to be contacted by third parties saying, oh, the stalker's at it again, telling men to rape you. The stalker's at it again, saying that you're a drug addict. We want to be left alone.
Is that clear? I mean, I'm
Yes.
not sure I can write anything that's making any more clear than.
I have left them alone. This is malicious prosecution. That's all this is. I have left them alone. I will continue to leave them alone. I will continue to move farther away to wherever they think, or they think that I think that they are. I don't want anything to do with these people. I've gone through this for 2 years, spent almost $40,000. Okay, I'm exhausted. It takes me 20 hours to get here.
That's good.
Wonder where you're flying.
Far away from here.
Violation.
Oh, come on. Look, I'm
Dude.
going to issue a executive order. And I think that whatever the executive order says will be interpreted by everybody in different ways. So I'm just going to make it as simple as I can. And leave it up to another
Thank you,
judge.
Your
It
Honor.
has to be interpreted some other day.
Where can I have my contract?